Is your immigration case stuck? Here's how to file a writ of mandamus for immigration delays. Still waiting on a decision for your immigration case even after months or years of silence? You're not alone, and yes, there's something you can do about it. It's called a writ of mandamus, and it just might be your best path forward when all else fails. U.S. immigration delays are common. Whether you're applying for a green card, a visa, or naturalization, you could find yourself stuck in limbo with no updates and no end in sight. These delays can affect your ability to work, travel, reunite with family, and generally plan your future. But under federal law, you have a right to a decision on your immigration application, and if the government is dragging its feet, you can take action. A writ of mandamus is a lawsuit that asks a federal court to force a government agency, like USCIS or the State Department, to do its job and process your case. It doesn't guarantee approval, but it does get your case moving again. Over 7,000 of these lawsuits are filed every year, and they're becoming more common as backlogs grow. A writ of mandamus can compel USCIS or the State Department to process your application, break long delays and push your case forward, and hold the agency accountable. But it can't guarantee that the agency will approve your case, change existing immigration laws, and help if your case is missing documents or the delay is justified. You may qualify to file a writ of mandamus if your immigration application was filed correctly, the agency has a clear duty to act but has failed to do so, your case has been unreasonably delayed. Courts often view delays longer than 6 months, especially when outside published processing times, as unreasonable. You're facing hardship because of the delay, and you've tried everything, including submitting service requests, contacting USCIS, and asking your congressional representative for help. To file a writ of mandamus, you'll typically need to include a formal complaint explaining your case, legal arguments showing the delay violates the Administrative Procedure Act, and a request asking the court to order the agency to act. So how do you actually file a writ of mandamus? Step 1. Talk to an immigration attorney. A writ of mandamus is a complex federal lawsuit. An experienced attorney can help you assess your eligibility and prepare your case. Step 2. Gather your documents. Include your application, USCIS communications, and records of your attempts to resolve the delay. Step 3. File the lawsuit. Your petition must be submitted to a U.S. District Court, not a state court. Step 4. Serve the government. You must formally notify the agency and the U.S. Attorney's Office. Step 5. Wait for a response. The government has 60 days to act. They might process your case, negotiate, or fight the lawsuit. Step 6. Be prepared for the courts to challenge your case. Some cases go to court hearings and require further legal steps. Most lawsuits are resolved in 3 to 6 months, though more complex cases can take longer, especially if the government contests the case. As far as costs go, the filing fee for a writ of mandamus is usually around $400 to $500 depending on the district, and attorney fees can range from $2,000 to $10,000 or more based on the complexity of your case and your attorney's rates. If you can't afford a lawyer, platforms like ProSePro offer self-filing kits with templates and step-by-step guidance. Delays don't have to mean defeat. If you've done everything right but still can't get a decision on your immigration case, filing a writ of mandamus might be a good option to help move your case forward. Want to learn more? Tap the link in the description to read our full guide. And don't forget to like this video and subscribe to our channel for more immigration news, resources, and tips.